Good evening, everyone, and welcome to our Monday Night Live. We are about to get started, and our topic this evening is Set Your House in Order. And we tell you more about that shortly. Our invited guest is Elder Dale Scobie. He's also an attorney at law. And so let us have a word of prayer. Our Heavenly Father, we give you thanks for this evening, and we thank you for your servant, manservant, whom you have blessed us with in today's session. We thank you for all of those who are attending and those who would yet be joining us. And we ask for your continued presence and in our discussion. This is our prayer in Jesus' name. Amen. Right. So set your house in order. I'm talking to you from True Health Lifestyle Center located in Las Lomas of Trinidad and Tobago, where our goal is to help everyone who comes our way to heal the whole person, body, mind, and spirit. And just by way of announcements, we are in the midst of our medical missionary training. If you are still interested, now is the time to join. It's not too late. All of our programs, they've been recorded, and so you can catch up quite easily. Medical missionary training puts you at an advantage for personal ministry, ministering to others, pretty much serving humanity in the way in which Jesus did, in a compassionate way, and giving you the tools by which it would enable you to do that on a broad scale, both locally and abroad. And so our next diabetes support group, look out for that on the evening of Tuesday, February the 3rd. And there we continue into this new year of supporting those individuals with diabetes, helping them to overcome. And we do have some great plans for you this year. If you are someone living with diabetes, it got to change. And so we have some plans to help you do that. So make sure you stay tuned and you can be part of those activities. Similarly, for cancer, we have our cancer support group. So that's on the last Thursday of every month, whereas the diabetes is the first Tuesday of every month. On the last Thursday of every month, we have our cancer support group. And here, individuals who are living with cancer have an opportunity to keep connected in between times of visits or consultations or one-on-one connect. Then what do you do in between? So just being on a platform where we can even hear from others and what they're doing in their space, what works for them, any new updates we'll be sharing with you. And that comes regularly as the Lord blesses with information and experience and skills. So we're here for you. So that's the last Thursday of the month, and it's on next week, January 29th. And we have our carnival for those of you who are in Trinidad and Tobago, Carnival Getaway. And so that's an opportunity to come and spend some time at the center and get a taste of what it is like being here at a healthcare facility, one that promotes healthy living and healthy lifestyle behaviors, good healthy food. And so just to be here is an experience in itself, and it's quite engaging. It's a little bit different from our more our master programs where we have those master residential programs. This one is a lighter, so it's touch, calmer, lighter atmosphere, and fun and activity, segments and so forth that we have in this one. So it's in Carnival long weekend as well as Easter long weekend. Coming up next in March, this is the one. If you are challenged with some health issue, then this is the one to work with you doing all the varied therapies and that would help you to overcome your situation. This is one where all those testimonies that we hear that individuals would attend and help them see their way through to improve their health outcomes. So, and then the next one, I'll bring that other ad that's on Easter long weekend is another one of those short weekends that you can take opportunity 4. So we want to get straight into our topic for this evening, set your house in order. And we have with us our guest, Elder Dale Scobie, and he is a Seventh-day Adventist elder in one of our local churches. He is also an attorney at law for the past 40 plus years. So bringing to us many decades of experience and in the civil sphere of things in private practice. And I have known Elder Scobie to be quite a pleasant gentleman, right, really approachable. And so should you need his services, I'm sure your experience is going to be a blessed one. And so I've invited Elder Scobie to come this evening and share with us some information from the legal aspects of things. But just before we get into there, I just want to bring this text and quotation, and then we hand over to Elder Scobie, where he would also shed some light upon what we're looking at and some more details from a legal perspective. So if you look in your Bible, I was thinking that in today's world, we are seeing a lot of individuals beginning our year 2026, and the month is not through yet, and they are gone. Towards the end of December, similarly, individuals in 2025, a number of individuals left us. And sadly, it was, for some, it would have been being ill until their end of departure, but for many, it was sudden. And you may have had friends or family members where that occurred. At one point, I started just to keep a little PowerPoint file of all of these programs that I was just seeing popping up of individuals whom I knew and to put like in my little album of remembrance because you couldn't keep up. And it's not only here for us locally, but around the world, it's happening. And unfortunately, for me being in the health space, I'm seeing it quite obvious. So we are at the end of time, and many may be put to sleep to preserve them and to keep them from the perils and the trials that are yet to come, that they may not be able to bear. But as the Lord is gathering his jewels in, what are we doing and how are we preparing? So we even look in the word of Isaiah chapter 38, verse 1, where Hezekiah, he was sick unto death. So his condition was one where, the doctors of his day would have looked at him and said, pretty much, we're working with you, but it's a terminal condition, or, he was seeing himself on a decline, and he inquired of the Lord, and the Lord sent a message to him through the prophet Isaiah, saying to him, set thine house in order, for you shall die and not live. His situation was going to bring him to a certain death. And he wasn't prepared for that. And so the Lord said this to him through prayer and supplication. The hand of the Lord moved and extended the life of of Hezekiah for 15 years more. Just like the prophet Jonah had gone to Nineveh with a declaration that God is going to destroy the city. And the king said, no way. We don't want that. We're not prepared to be destroyed. And so they turned to the Lord and prayed intercession time. And so the Lord spared them. So God has a way. And maybe you've had that experience too in your life, or someone close to you in your church, in your family, when you've joined in prayer and see the Lord's hand turn things around and the person's life extended, that is wonderful. That's perfect, is the Lord's doing. What we are looking at here, God still told Hezekiah to set your house in order, even though he, knowing all things, knew he was going to extend his life. So we shouldn't wait till we are at the ultimate end when we feel that we're sure we're going. You may not have that opportunity. You may leave. You get up in the morning and by evening you're gone. That happened with my dad. Got up on Sunday morning, bright, sunny, active, no aches and pains. But by nightfall, he was gone. And so it happens to a lot of people, and we don't want to be caught off guard that we are not prepared spiritually. That's why every day we commit our lives to the Lord and live it as if it were our last, and not in fear, but in readiness and joy. And then we gotta be ready physically, you gotta be ready mentally, knowing we're not here forever. So looking from a biblical perspective, even though you're alive and kicking and well, it is not beyond us. It's not a lack of faith to set your house in order. And I got some statements here from the book Counsels on Stewardship, and it gives us a little guideline about putting some will in place, some document in place, which Elder Scobie is going to talk to us about what that should look like and give some advice. And I'm not sure if he has these same quotes, but I just want to run through this for us, and then we switch over to him. It tells us here, it often happens that an active businessman, the businessman is active, that he's cut down without a moment's warning. And on examination, his business is found to be in a most perplexing condition. So he's gone, he dies, he passes, but it's a complexity around sorting out the affairs of the business. In an effort to settle his estate, the lawyer's fees will eat up a large share, and if not all of the property, while his wife and children and the cause of Christ are robbed. Those who are faithful stewards of the Lord's means will know just how their business stands. And like wise men, okay, be wise, have wisdom applied here. They will be prepared for any emergency. So we're looking at guidelines as to what we should be looking at. And let us be prepared. And should their probation close suddenly, they would not leave with great perplexity upon those who are called to settle their estate. So I'll pause here. There are a couple more statements, but I'll pause here and invite Elder Scobie now to share with us what he's prepared for us this evening. So Elder Scobie, I see you right there. Do you have slides to share?
I do, I do.
Okay,
Yes.
but go ahead, you can. Thank you.
Well, thank you very much, Dr. Nash, and a very good evening to everybody. It's a pleasure being with you, sharing your platform with you. I want to thank you on your platform for sharing with us your expertise on national radio on our program Heaven's Final Call. Your contribution has added tremendously to the information our listenership actually gets, and it's a delight being with you this evening to spend these moments. Well, we're going to be talking about some legal issues. I'm going to be looking a little broader than a will. We're going to deal with some situations. Even while we are yet alive, we need to set our house in order for living issues. And of course, we're going to be touching on wills as well. So let me share, and
Elder Scobie,
okay.
your
Oh my
volume.
goodness. So
I
I
know you
got
were
to switch back
testing.
here.
Yeah, you were testing your volume earlier. But right now there's a little background muffle, so it's not
Where
altogether clear.
it's
Is
coming
there
from
any
me?
adjustment that you can make to your volume?
All
Um,
right. Is it too loud or is it too soft?
it's audible, but in
How
the
is it
sense
now?
of we could hear, but it's a bit muffled.
A bit
Um,
more. All
like
right.
it's crisp clear to really get everything.
Let me see. Is it any better now?
Yeah, sounding better. Audience, what do you think? Keep
Is
speaking.
it better?
Coming.
1, 2, 3, 4, 5. Is it sounding any better or still not?
No,
Did you hear?
Okay.
Cynthia says,
Okay. One, two,
um,
three. It needs 1, 2, 3, 4, 5. 1, 2, 3, 4, 5.
yeah, they're sounding a little better, clear in terms of clarity.
Uh-huh. But
Uh-huh.
in terms of volume, is it any better now? One, two,
It's
three, four, five.
better.
Huh?
yes, better, perfect.
All right, beautiful. Well, let me now share. Let me see where I'm sharing. Okay. Am I right there? Yes?
Yes, it's
Okay,
from you.
beautiful. Well, we going to be talking generally about some legal issues, the law working for you, and of course, in the context of setting your house in order. All right. Let me just minimize. Beautiful. Okay. The question we're going to be looking at, how do I manage my affairs and decide what to do when my property with my property when my ability to do so decreases? The truth is that very often, even during our lifetime, situations develop where you need to have set your house in order or to take steps that would take care of your business affairs because of unforeseen situations that arise. And I just want to walk you through quickly some of those situations. Some you may have been exposed to, you may have thought about before. There may be others that you did not think about. We are dealing with a couple. Let's take this scenario, Roy and Margot, husband and wife. They have 3 children, one of whom, Caroline, lives with her parents. Roy and Margot acquired some property during their lifetime. They have a car, they have a house and a lot of land, savings, pension, NIS. Now, Roy suffers a mild stroke, and so he is unable to walk without help. He is mentally alert, but unable to go to the bank to conduct his business affairs. Now, this is not an unusual scenario. It happens more often than we would like. You are alive, but you just physically, you're not able to attend to your affairs. Sometimes it happens with elderly persons. It could happen sometimes with even younger persons. So we are treating with this family, and Roy, who would have been the the breadwinner, main person in his family, is now unable to attend to his affairs. Let me say first that the information which I'm presenting this evening is general advice. It's not legal advice. You need to consult your qualified legal professional for specific advice to your particular situation. But I'm just going to be dealing with legal issues that arise so you would have a general background idea as to how to deal with them. So, taking care of business. In such a situation, the document called a power of attorney is very useful. What the power of attorney does is a legal document in which you name someone that you trust to carry on your business affairs. Go to the bank for you, for instance, where he could appoint his wife, he could appoint his daughter by a power of attorney. And that person, who is someone that you trust, will be able to do whatever business transaction you could have done. Of course, this is a document which you can also revoke, and the it's a deed which is registered, the power of attorney. It could be a general power of attorney, which gives the person you appoint a wide range of authority. They can do banking transactions for you. They can do, if you want to sell the property you have, if you have to go to any government office, any transaction that you are now not able to do, because of your disability, that person would be able to handle on your behalf. Of course, the power of attorney is a formal document, which is a deed, which an attorney drafts, and it's registered as a deed, and a certified copy is given to the person whom you are appointing as your attorney, and with that, they have authority to handle any transaction you could have gone and handled yourself. There's also, you have a general power of attorney, which gives wide powers, or you may have a special power of attorney, which gives specific powers. You may just want somebody to be able to handle your banking transactions. You may not want them to be able to sell your property and all of that. Okay, and you may just need a power of attorney to handle. Suppose you have a building you're renting or a parcel of land where somebody is taking care of it. You can give authority, so someone now has all your authority to do what you could have done when you were well. So generally, you have general powers of attorney, or you could have special powers, specific powers. Of course, you need to consider carefully who you are selecting as your attorney. Now, this is not the attorney at law we're talking about. This is any person, your relative, your daughter, your spouse. You can apply to, you can appoint in this formal way. The powers of attorney you want to give, right? You have to determine what authority you're giving this person. Some people, sometimes somebody might be leaving the country and you want someone who is here to handle certain affairs which you cannot handle yourself. So a power of attorney must be registered as a deed to be valid. And if you want to cancel this power of attorney, which you can do, it has to be cancelled by a deed as well, a deed of revocation, which is also registered. So a power of attorney is the first document you need to be familiar with that you can use in case of. Now, a power of attorney comes to an end when a person dies. So if you have a power of attorney in place, it is not sufficient to deal with your affairs when you die. It's not sufficient because the power of attorney is only valid while you are alive. Not only while you are alive, but it is, strictly speaking, it is only valid while you are in your right mind. So if having done a power of attorney, somebody gets dementia, Alzheimer's disease, something like that, and they are not able to know what they're doing, the power of attorney, strictly speaking, is no longer valid. Of course, I know many instances where you may continue banking transactions because the bank might not be aware that the person has dementia or something like that. So the power of attorney has value only one, while the person is alive. A death, it is now void, it has no effect. And if you are not in your right mind, it means you do not have a continuing authority to authorize someone to do those transactions for you. So that a power of attorney could never take the place of wills, as we were talking about wills. Now, wills are, of course, a different kind of document, and they are not as formal as a power of attorney. While a power of attorney has to be registered as a deed, and it has to be cancelled as a deed by the deed of revocation, a will is not as formal, even though it is as important. What a will allows you to do is to decide while you are alive and in your right mind. It helps you to decide what happens with whatever property you may have accumulated during your lifetime. So that property you would have accumulated is called your estate. So we generally know that the estate refers to, we say an estate means that you have a piece of land somewhere that you're working, but whatever you have, whatever a person dies and leaves, if it's just their property, personal property, if even there's no bank account, there's no real estate, you still call it their estate. The estate is the term given to whatever a person owns, whatever they would have left at death. So you are going to decide what happens to your property after you die, and what allows you to do that, of course, is a will.
Now, what is a will? What do you do in a will? One of the first things you need to do when you're preparing a will, you need to think of someone who you have confidence in. This person will carry out my wishes. That person is called the executor. That person is named in the will. You want to put as much information there about them so that they could be located, they could be identified. So you put their name, you put their address, and if it's a relative, you could mention who the person is, just in case there's someone else who has the same name who might, present themselves. But of course, you're the executor. Then, of course, you need to decide what you want to do with your property. When you make a will, some people seem to think that when you make a will, that it means that you're going to die. Absolutely not. A will has absolutely no value until death. So while a power of attorney has no value after death, a will is it kicks in, its value kicks in at death. At death. It's effective at death. It means that when you make a will, you can change the will at any time. I once knew a colleague of mine. This person would come, well, almost every month to change their will. That's a change, but that's your prerogative. If you are unhappy or probably some part of your estate, you're probably exhausted and you want to change up the way you distribute, you have that right. You can change a will any number of times. And the last will is the valid will. So if you did a will 10 years ago and and somebody at death presents that will 10 years ago, and there's another person who have a will that was done 1 year ago, the will 1 year ago will supersede, and the older will would generally, be invalid. So it can be changed at any time. Of course, in the will, this is another sometimes, I mean, you can make your own will. You can make your will. We talk about the formalities. There are some formalities that accompany the making of a will. And if you do not comply with those formalities, the will would not be valid. Of course, the last thought there is that a will usually has what we call a residuary clause. Now, you may make a will which deals with all the property you know you have. But just suppose somebody left property for you in their will that you didn't know about, and that property comes into your estate. The residuary clause is a clause which covers all property which you know about, which you don't know about, be it real or personal, even property you may acquire after your death. And that's a very important part of the will, because if you don't do that, you will find that you have part of your estate dealt with in the will, and the part that you didn't know about will go according to the letters of administration. It will go according to rules which are beyond your control. But if you want to deal with all the property, you include the residuary clause, which covers everything that you did not specifically mention in your will. So that is generally what the will is about, generally the issues that arise there. Now, what makes a will valid? Will it be valid? In order to have a valid will, it must comply, okay, the law, the Wills and Probate Act. But of course, it's quite simple. You could do a will in your own handwriting. Generally speaking, the courts bend over backward to support a will. Once it is clear that you intended to do a will and the formalities are there, there is a tendency to support that will, to find it valid. So you can do it in your handwriting. But because it's such an important document, you want to be sure to do it as clearly as you can. You have it typed, you have legal advice. You don't need a lawyer to do a will. You need a lawyer to do a power of attorney, but you don't need a lawyer to do a will. A power of attorney must be signed in front of a lawyer. But with a will, you do not have to have a lawyer, but it's advisable because of the importance of the document to have legal advice, have the best advice. And the best advice on legal matters, of course, will be someone who was trained to give that advice. So it could be in handwriting, as I said, but it's better to have it typed up in a formal way. The key thing about a will is that it must be witnessed. Not just witnessed, but it must be witnessed by two persons. And we're dealing here with adult persons, all right? It must be witnessed by two persons, and not just two persons any way you choose. You can't make a will and go by one person and have them witness it for you, and then go to the home of another person and have them witness it for you and say that's valid. People may have done that, and because nobody can challenge it, because nobody knows how it was done, then it goes through as valid. But the law requires that there should be two persons at the same time with you, and all they have to do is to witness your handwriting, your signature to the will. They don't have to read the will, they don't have to know what are the contents of the will, but they just have to be there together at the same time and witness that this is your will, you are signing. And of course, there are clauses to that effect on the will. So basically, you have an executor, you know what you want to do, you have it expressed as clearly as possible, who you want to give what, whatever you decide. Good to have the residuary clause, which deals with property that you're not aware of, that may, as I said, you may have property coming to you that you did not even know you had, and that sort of thing. So that residuary clause deals with that. And of course, it must be signed by two persons, two witnesses who are present at the same time. Now, there are other issues relating to that little simple issues that I will share. Who can witness your will? As I said, it needn't be a lawyer. What about the executor, the person you're appointing as executor? Could that person witness your will? Yes, they could witness it, but if they witness it, they cannot be the executor. You cannot have an executor who's also a witness of the will, because of course the law wants to be sure everything is quite transparent, there's no conflict of interest, and if you witness the will, you may have influenced the person to make you the executor and all of that. Those are the little precautions that are taken to ensure fairness and to ensure that the wishes of the deceased, the person who dies, the person who makes a will when that person dies, you call them the testator, if it's a man, or the testatrix if it's a woman, the deceased person. All right. So the executor cannot witness. What about beneficiaries? People who are named in the will as beneficiaries. In other words, they are named as getting some part of the estate. No, they cannot be witnesses. If they are witnesses, then it will forfeit their claim to a share of the estate. So these are little measures that are put in place to ensure there is no conflict of interest. So if you witness the will and then the entirety of the estate is left for you, you know, there could be the thought probably you held a gun to his head or something like that. So the Lord tries to ensure that there's that fairness in terms of those formalities. So basically, that's basic information concerning a will. What about if you did not leave a will? What happens if you did not leave a will? Of course, the big advantage with a will is that you get to decide what happens to whatever estate you have, whatever property you may have accumulated during your lifetime. So if you want to give something, Leo wants to give something to his wife, he wants to give something to his daughter who lives at home, and he wants to give to the 3 children or the 2 children. He might want to give something to the church he belongs to. All of that you can specify in your will. When you make the will, you maintain control as to what happens to your property. If you do not make the will, the law of the land decides who gets your property. The law of the land decides that. And then, of course, you have the Administration of Estates, the Succession Act. There are acts which specify. And of course, that is decided in levels of priority. And briefly, I would give you an idea as to how that goes. let's take Margot and Leo, and they have 3 children. When someone passes, the first person who becomes entitled to the estate, you call that person the next of kin. Kin would be close relative. The next of kin will be the closest. And the closest who are the next of kin of the deceased will be the spouse of the deceased person and the children. So the spouse and the children, they are entitled. So if someone dies without children and only leaves a spouse alive, the spouse will be entitled to the entirety of the estate, entirety of the property of the deceased person. So if there's no will, it goes to that person. Of course, you have to apply for letters of administration as well. Similarly, you have to apply for letters of grant of probate. And that we'll talk about the application for a few moments afterwards, right? So if there's no will, you do not get to decide if you wanted to give some property to the property, as I said, would go to spouse and children. 50-50. Half of it will go to the spouse and half of it will go to the children. That is the first priority in terms of inheritance. If there's no spouse and you only have children, then the entirety of your estate will go to the children. As I said, if there are no children and only the spouse, the spouse will get the entirety. If you have spouse and children, it will be divided 50% for the spouse, 50% for the children. And of course, if there is no spouse, all goes to the children. If you have no children and you have no spouse, the next in line will be your parents, if you have parents alive. Next in line will be your parents. Parents will be entitled. Next in line. So you have spouse. Of course, the spouse is the one who has the first right to apply for what we call letters of administration. So if there's no will, the law specifies who would be entitled to the property. As I said, certain priorities, spouse and children first in line, then parents, then siblings, brothers and sisters. Of course, apart from the law determining who will get the property, the law also decides who is entitled to apply for probate. So the law says the first entitlement goes to the spouse, husband or wife. And the second entitlement goes to the children. The third entitlement, the third priority, would be the parents. And then, of course, the siblings. And there are rules which will determine down the line if there's no spouse, if there are no children, if there are no parents, if there are no siblings, there are rules which will determine so that we're talking about a situation where the rules of the law will determine who gets what, and you will have absolutely no say. So the advantage of a will is that you can put your house in order. If you don't, then the courts would put your house in order for you. Now, when it talks about children, there are people, strange situations sometimes develop. Strange situation. Even in the event, even if persons are estranged, let's suppose husband and wife have separated for 20 years, but they've never divorced. And you may have been, you may have, relatives might have taken care of you, and then you die, that spouse can come and claim because that relationship of priority where there's no will still applies. Similarly with children. Children are able to of course, based on that priority, that's what the law deals with. So when you leave a will, then in order to carry out the terms of the will, you have to apply to the court for what we call a grant of probate. But the executor in that will is able to take charge of your estate, your property, even before he obtains probate of the will. By virtue of the will, that person becomes the custodian, responsible for taking care of the property. Of course, in the case of the administrator does not have that automatic authority. The administrator has to get that when he's appointed by, he applies for letters of administration and he gets that authority. So even in terms of immediate control, the will gives that executor authority, a level of authority immediately from the will to take control of the property of the deceased person. Letters of administration would have to be applied if there is no will, and you have to await the grant before you get that authority. Now, apart from, so we've looked at powers of attorney, we look at the will, we look at the situation where there is no will. Of course, there are steps that could be taken during your lifetime to manage your affairs apart from waiting until death to distribute. Of course, we said that a will could be changed at any time. A deed of gift is another type of legal document where sometimes as parents, as adults, you decide beforehand, you know beforehand that there are certain things that you want to give to other people, maybe your spouse, maybe your children. You don't want them to have to be applying for probate, or you don't want them to have to be applying for letters of administration. But you want such a situation where when you die, everything is already settled. And whoever has to share in your property can share. Of course, if we're dealing with a bank account, one of the things that you can do, if you trust the person sufficiently, you could appoint them as a joint account holder with you. I know there are many people, sometimes they are spouses, husband and wife, who will do that. Sometimes parents do it with their children. The thing about a joint account, of course, is that the person who is a joint account holder becomes the owner of whatever you have there at your death, because the joint account actually is saying that both of you own it equally. And that person, so if it is your desire that that account should be shared up among various persons at death, the joint account is not the best way of doing it. Because the person who is the co-owner, I'm repeating myself, joint account holder, can claim the entirety of it. So apart, well, of course, joint account will allow you, the person, to do all the transactions for you. You would go there and that sort of thing. So, all right, now, let me just say this again. Even if you mention in the will that the money in the joint account should go to 5 different persons, the joint account holder does not have to respect that. That joint account holder can go to the bank and say, request the money that is there, right? Unless, of course, the bank has a special arrangement with special instructions. But generally speaking, the joint account holder is entitled to all of it. So that's something to take note of. As far as property is concerned, call it real estate as opposed to personal estate. Property, you can do a deed of gift. The thing with a deed of gift is that once you do a deed of gift, transferring ownership into another person's name, you cannot change that unless the person agrees to sign it back to you. So this is permanent, it cannot be reversed, but you may have come to a decision, this is what I want to do. So a deed of gift means that there is no money paid. You do a legal document. An attorney, once you're talking about a deed, it has to be done before an attorney, and he conveys the property from you to the person whom you want to give it to. Now, there have been many cases where persons thought they want to do a deed of gift, and sometimes the very property they're living in, they say, yeah, I want to do a deed of gift. I want to get this off my hands. I don't want my family to have to be, jostling over it when I die. In such cases, whenever someone comes to me to do a deed of gift, I would inform them clearly as to what are the implications. And that introduces the thought that, of course, there are different ways of doing a deed of gift. I would always advise the person, listen, it's good to retain a life interest in the property, or it's good to have it transferred, to whoever, to yourself and that person jointly. A quick scenario, you are sure you want to give this property to your eldest son, as the case might be. Eldest son is married. Of course, you are there and your wife has died. Let's suppose it's a gentleman or your spouse has died and you want to give it to your child. You're clear about that. So you do a deed of gift and you give it entirely to this person. It is possible that that person could die before you. And if that person dies before you, then their property, if they didn't make a will, the property will go to their spouse and you will be without the property. The spouse is there. Depending on your relationship with the spouse, you may find yourselves out of the property. That's just a practical situation that. So that's as much as we. So we're talking about a deed of gift. Generally, if you can retain a life interest as long as you are alive, you own it, and when you die, it automatically goes to the person, so you don't have to do a will. Or you can do a deed where you own it jointly with the person. Jointly means that whoever dies first, the survivor would remain the owner. Of course, there's another type of ownership, but I just mentioned that. All right. The final thing that I want to touch on is, which shows why it's important even during your lifetime to make adequate arrangements, is something which we call the guardianship of the elderly. Now, I'm going through these four issues very briefly. I hope I'm not okay. Well, of course, I trust you'll be able to ask questions, and I'm dealing with each of them pretty briefly because I know these are the areas where we are impacted unwittingly. It happens, it creeps upon us, and these are the issues we need to, more or less, some of the issues we need to clear out. Guardianship. What is this about? This is a situation which develops guardianship of the elderly, and guardianship, I mean, it sounds very strange. How could you normally are a guardian for infants, not for the elderly? And it's a shocking thought. Guardianship? Yes, guardianship happens. You may have someone who probably didn't do okay, who is mentally alert now, but dementia sets in. And when dementia sets in, you have to decide what happens to that person's property. They might have been getting a pension, they might be getting rent from properties and all of that, but they are no longer able because of Alzheimer's, dementia, something like that. They're not able to conduct their affairs. So mentally, they cannot make a power of attorney because they're not able to do that anymore. They don't have the right frame of mind to give anybody authority. They cannot make a will because they don't have what you call testamentary capacity. They cannot make a will. What do we do? Now, making a will, setting your house in order before these conditions come. Sometimes there might be the early signs, and you need to do certain things when the early signs are there. Sometimes as a matter of fact, you don't have to wait until signs to do it. These are things that should be done. A will, whatever you want to do as early as possible. But what happens when a person is now unable to manage their affairs? What happens? The law also deals with that, and that's under the Mental Health Act. And simply, what it requires, of course, we have to remember under that situation, you have no control. You have no control over that. This is done without your wishes because you are not able to give consent. So it's a step which is taken. You have no, you cannot determine anything about it. And of course, the law will supervise. The law will supervise as to what exactly happens. Yes, that can happen. The person who can make an application to the court to be appointed as your guardian, the law prescribes who that person could be. And of course, top of the list will be your next of kin or close relative, next of kin. That person applies to the court. They have to get medical certification that you are not able to conduct your affairs. So a psychiatrist, one or two psychiatrists, doctor, will have to give a medical certificate saying that you're not in the right frame of mind to conduct your affairs. So it's not just willy-nilly anybody comes and says this person doesn't have that. It has to be based on a medical report, okay? That you're not able to conduct your affairs. And in addition to that, you need to have, is an application would be made to the court. You need to be able to identify what estate, what assets comprise the estate, comprise the property, whether it's income, whether it's a bank account, whether it's property, life insurance is listed. The court becomes the supervisor. And of course, in addition to the medical report, you need to have one or two persons as witnesses who can give evidence as to the fact that this person has lost their, but is not able to conduct their affairs. And on that basis, the court would make an order appointing that next of kin or appointing the applicant, appointing that person as what you call a committee. And that committee takes care of the affairs, business affairs of that person. It's made without your permission. Of course, if you made a will before, that will would still be valid. Right? If you made a power of attorney, the power of attorney would not be valid because the power of attorney is only valid if you are able to, on a continuing basis, give that authority. Right? The next of kin is the one who will be usually, okay, presentation, right? Of course, right, mentally able. So that basically is the situation when you have lost, when you're no longer able to conduct your affairs. The courts will appoint someone, an application, and that person will manage. Of course, they will manage it hopefully in your best interests. But of course, if you had made a will before, that will would stand. If you didn't make a will, it means that letters of administration and the law will decide what happens. Right? I think I have given quite a mouthful. I will stop here. I had a scenario here which I would have suggested we look at, and okay, estate and all of that. But I think we will stop here, and I hope what I said has been clear. I said a few things. So, Dr. Nash, I would stop at this time if you if there are questions or anything like that.
Yes, thank you. Thank you very much, Dale Scobie. Lots of detail. It kind of reminded me of being in law class, I tell you. But
Did I?
great, yeah, it's quite clear to understand. So I see we have some questions in the chat, and let's take them. And I have a couple myself. So I think this was answered. What if someone becomes mentally unstable and the power of attorney is then invalid? How can the person who is identified initially as having power of attorney proceed? I guess that's where the mental act law would come in.
Yes, the power of attorney will cease to be valid.
Mm-hmm.
But of course, there's usually a part of the power of attorney that says it will be valid until notified. Because a person looking at the power of attorney might know that the person who appointed is mentally ill. So it protects that innocent person. But
Mm.
strictly speaking, once have lost that ability, mental ability, power of attorney is not valid. If a bank knows that, they'll tell you it's null and void as well.
Okay, and who would actually kick in that procedure? And I'm not sure if I missed that, but kick in the procedure for the Mental Health Act to take effect because a person
Right,
can report themselves.
right. The next of kin, the
Okay.
next of kin, the person who is taking care of that person. The law also identifies like a social worker someone who has that nexus with the person, sufficient nexus with the person, could
Right.
apply. A son, a daughter, a spouse, a relative, you know.
Okay. All right. Very good. Let's see. What if more than one person applies? Sister Walcott, you want to clarify applies for what exactly? I'm not sure if Elder Scobie are able to follow. What if more than one person applies, example, children?
Applies for,
Yeah, I'm not sure because we covered so many things. Just put in the chat and Esther Walcott, exactly which of the areas you're referring to. And I had a couple questions. So one, looking at the um, residuary clause, what kind of words are we looking for in that clause?
okay. Well, okay, for instance, I can think of one clause used is that any other property, whether real or personal, which I may have or to which I may after my death become entitled to, right? It's an
Yes.
all-embracing clause. So you want to identify any property which you have, whether real or personal, to
Mm-hmm.
which I am entitled or to which I may after my death become entitled. So it's that kind of a catch-all
Yes.
phrasing that
Yeah.
deals with anything that comes into your estate that you did not know about.
All right, very good. Because, as we mentioned, a will that anyone could write a will. So where will that will be deposited? You keep it in a top drawer somewhere. Who knows about it? How would we pull it out, find it, show it to whom?
Okay. Now there's no legal requirement with
Uh-huh.
respect to where you keep the will. Of course, you want to make sure it's safe. There is a provision where you can go to the court and your will could be deposited in the probate registry. If you go
Mm-hmm.
there, it's a small sum of I think just a sum. Well, long ago it used to be stamps. Not sure what it is now, but you go to the registry, and there's a depository of wills there. You can have it lodged there. And at death, one of the first things that is done if you're applying for someone's estate is that you have a search done. And the registry will indicate whether there's a will lodged there or not. But you want to keep your will in a safe place. If a will is presented to probate and it has any markings or it is torn or it is creased and all of that, you have to do what you call an affidavit of plight. You have to account for those damages or smudges, or so you want to keep it in a place where it's going to be protected. And of course, you don't want to expose it to someone who may have interest in destroying it. So you want to have it. Some people might put it in their vault in the bank. You don't have to go through that expense. You may even want to give it to, if you have a trustworthy executor, who you may want to give it to. But of course, no one has to know what's in your will. You don't have to tell anybody the contents, not even the witnesses, so that it's purely a matter of up to you. And you want to, sometimes you may leave a copy with the attorney, there are all of those things, but there's no specific requirement where that is concerned. It must be kept in a safe place.
Very good. So I do one, I keep it in a safe place in my home. There's no adverse relations in the home, so my family could literally pull it out and present it as need be, say to the bank, to the licensing office to transfer my vehicle to whomever I bequeath the assets to. That's how it can
Not
work.
not really. Before a will is before the estate could be administered, before you can deal with the property in the estate, you
Mm-hmm.
have to first apply to the court for a
Okay.
grant of probate. You see, the court supervises the estate. There's a doctrine that sort of says that whenever a person dies, immediately all their property will vest in the administrator general. Administrator general becomes the owner of all that property. So now you have to apply to the court to get a grant, which appoints you to sell what has to be sold, to transfer the car, to go to the bank. You cannot just take the will and go to the bank and get access to the property. Of course, they tend to allow a certain amount for funeral arrangements. But
Mhm.
generally speaking, you have to obtain a grant of probate before you can touch. Well, administration, you have to get letters of administration. Okay? The executor of the will has access to the property based on the will, right? He can take charge of the building. He doesn't have access to money in the bank, but he has
Mhm.
access to taking care of the house, real estate, that sort of thing, paying the insurance. Well, not paying the insurance. He cannot touch that. Okay? In order to access it, to admit, to divide it and all of that, you must first obtain a grant of probate.
All right. And so you said apply to the court to get a grant of probate to appoint you. Who is the you?
That's the person named in the will as the executor.
Okay.
And of course, if the executor has died before you or so, there are rules which will determine who will be the next in line. For instance, if you name an executor and that person dies,
Mhm.
the next in line, of course, will be the person who gets the residue. So there are rules that will determine these things.
It sounds pretty much like we certainly need a lawyer. Certainly need an
Well,
attorney to hold your hand and walk you through this. You know, so though you have it, it may be lodged in a bank, maybe lodged in a registry. You have a copy at home. Event takes place. Find an attorney who would be able to help you to apply for these letters of administrations and so forth. Okay,
but
got
even
it.
if your will is destroyed,
Uh-huh.
even if your will is destroyed and you have a copy, that can be admitted to probate. There's a procedure for that as well.
Okay. Yeah, I think so knowing this today, I can put a note on my will that this needs to go to an attorney and they'll walk you through the rest. Well, okay, sounds pretty good. And let me see any more questions. When it comes to dividing, we talked about the spouse having first preference, then the children. What about if the children are not shared children because the one spouse came in but met the person who died with children already. So it's those children who would be entitled, obviously, or if those children plus any shared, any variations around there.
Okay. So I think you're talking about like the blended family situation where
Yeah.
you might have had children from one spouse and other children with the other spouse that were not fathered or mothered. That sort of situation. Yeah?
Yes. Yes.
Okay. The children, the natural children are the ones who would become entitled. There's a that is a okay. If you have, I shouldn't just say the natural children, the lawful children. If, for instance, you adopted somebody legally, that person would be like a child, okay? But the children that uh, my children would be the children that I would have fathered or I would have adopted, and my wife's children in that scenario would not be entitled to share in my estate.
Because you have your offspring already.
Right. Well, in terms of the blood relationship, now there's a little that the notion of the child of the family, it's a little, it's something that I will reserve my opinion on because there is a doctrine where if you accept a child as the
Mhm.
child of the family, even though there was not official adoption, that there are obligations if that person is an infant, as an infant. Let's say that's an area to be treated a little. It might just be an entitlement to maintenance as opposed to an entitlement to an inheritance of a share, right? Because there are some situations where there are provisions to maintain dependence,
Mm-hmm.
even though you're not entitled to inherit as a, natural biological child, right? But generally speaking, we're talking about biological relation. Of course, there's a interesting situation, which, of course, it does not. I don't think it doesn't apply to Seventh Day Adventists generally who are married. But there's an interesting cohabitational relationship act, which gives rights of inheritance to uh, common law relationship, that sort of thing. But of course, we're not really dealing with that, right? You're dealing with
Right.
children who will grow up in the family, but they were not the children of the deceased.
Yes, yes,
Right.
yeah. Quite interesting. All right, I see we have a hand and then we have a couple more questions in the chat. Dawn, you can go ahead and unmute yourself, please. Yeah.
Yes, good night. Good night. Very powerful information. I have a couple of questions. Once the will and everything has been shared for the family or whoever it needs to be, is there taxes um, due on that property or the money that's in the bank? Do they have to pay tax on that?
You're talking about like land taxes and so on?
No, like regular, I'm sorry, in the States here, if we receive money in the bank, if they receive it with a will, and let's say
Uh,
there's a quarter million
oh,
dollars, $1 million, or 20,000,
okay.
10, it doesn't matter. It's still tax
Right.
due on that money. Is that
Right.
also the same thing?
Whether there are taxes on legacies, that's what I really can't tell you. I do not know offhand. I can't say. I know estate taxes and so on were abolished in Trinidad and Tobago. There was a time when you had to pay estate duties and that sort of thing. You no longer have to pay those duties. But whether it would be treated as income, I don't, I couldn't say. I couldn't say that. I guess that's an accountant would be able to tell you off the tip, but I really couldn't answer that question. I'm sorry.
Okay. Okay, and one more question. I have a couple of more questions, but I just put one more question. Let's say that person owe the bank a great deal of money. Um, and they inherit, let's say they inherit again $250,000, and they owe the bank $10,000. Would the bank come and take their money before they get their set of money?
Okay. Now, the bank, of course, would not have automatic access to the estate, to the money. The bank would have to, okay, we're dealing here with cash. Of course, the situation might be a little different if it's a mortgage property. But if we're dealing with cash, the bank would have to go to court, or anybody you owe that money will have to go to court, get a judgment, and that judgment will have to be registered. Once that judgment is registered, then it will attach to any property, physical property the person has. I guess there are procedures where you can go to court if you have a judgment against that person in court. You can go to court, and there are particular remedies that could allow access to recover from the money they have. But those are particular. But the bottom line is that there's no automatic access to say you owe me X dollars and you have that in your estate,
Mm-hmm.
so I can go to the bank and get it. No, it has to be done through the court and through specific remedies that the court would prescribe. Of course, where land is concerned, if the person had land, real estate, and you have a judgment against them, you could register your judgment, and even if that land is sold, you could recover your money because you would have first claim. Your 10,000 must first be satisfied. once a judgment is registered against the person who owes money, registered, then any transaction involving the land, you have to do a search. And when you are searching, you're supposed to search judgments to see what is outstanding. That is a lien on the land. So that I hope that helps.
Yes, that helps. So they could put a lien on the land or on the money.
The land, yes, yes.
Okay. Okay, thank you.
And I guess even before the probate is or the letters of administration is granted,
Caveat.
That they would put an ad in the paper, in the Gazette, yeah?
Right.
So that
Well,
the
if you
opportunity
have,
is there for anyone, yeah, to claim.
yeah, I think if you have a claim against the estate, against the person, sometimes there's a procedure called filing a caveat. You file that caveat or caveat, and you lodge it there at the probate registry. But you have to show, you cannot just show that the person is owing you money. You will have to show that I mean, the person applying for probate or administration, as long as they have a clear line to do that, you cannot disturb that because the deceased owed you money. If the person who is applying is not entitled to apply, that's a different matter. But as long as they are entitled, you can't really, you have no claim against them to obstruct them in that regard. Of course, there are charges that could be put against the property, but it must be done through the court, and that's something you need, of course, to get this. This I would say you need legal advice to be able to know what is the appropriate remedy to deal with that situation. I saw a question. I saw a question talking about a deed of gift. It says, if you did a deed of gift, if you did a deed of gift for someone and that person passed, who does the deed of gift go to? Right. I think that's once you do a deed of gift, then it becomes the property of the person who you gave it to, the donor, donee. The donee is the one who's the beneficiary, right? That property will now go to the next of kin of that person. And that's the scenario I sort of described when I said if somebody wants to do a deed of gift, so suppose you want to give a deed of gift to your eldest child, right? Your spouse has died, you want to give the property to the eldest child, and you do a gift to that person, complete gift. I know of situations like that. And then the child died before you. The property will go to the next of kin of that child. Now, if that child has a spouse, it goes to the spouse, or it goes to the child, the grandchildren, but you will have no claim to that property. And that's why, in many instances, what would be more advisable is to either convey it into yourself and the child jointly. So whoever dies first, the property goes to the survivor. Or if you are certain you want it to go to that child and the children, you can do what you call a life interest, where you to yourself for life and after death to that person.
Very clear. Someone is asking about a trust fund. Is there a difference between the trust fund and a will?
There is a significant difference. Now, a trust fund is an arrangement which you establish where the property involved or the money involved is put into the ownership of a third entity with specific instructions as to what should happen to it, what should be done with it, so that you are no longer the legal owner. So this trust, you are declaring a trust, you're naming somebody or a bank or some entity as a trustee, and the trustee is now the legal owner. You no longer have control over that money. You've created that document, it's been registered and so on as a trust. And it specifies who should get what. You may say under this trust fund at age 18, this child should get, or this person should get, this money should go towards education or whatever, and that sort of thing. So that a trust is a document that is made where you no longer owns the trust, you no longer own the trust property. The legal title is in the trustee, and the beneficiaries mentioned are the ones who become entitled to the benefit of the trust fund. Now, many people have been inquiring about living trusts and that sort of thing. It's not a common practice here in Trinidad and Tobago, as I'm aware. I'm aware that it's a practice in the States, and I see no reason why it can't be done here. But it's an arrangement whereby you put this property into this trust fund, trust account, and you specify this and such should be done with it. So the hope is that at death, you no longer have to do anything. The trust will run. And there are trusts like that, where the trust will continue to operate because you donated the property, but you are no longer the legal owner. You have just specified in the trust deed what should happen to this property, how it should be invested, and that sort of thing. So that's the difference. A will, however, is where you decide what should happen to your property, and that only takes, you retain ownership of the property until death.
Mhm.
And the will only takes effect at the point of death.
Quite clear. Okay, and what if, I'm not sure if you answered this. What if you have your kids on a will as a beneficiary? What it would it have to be probated? I think yes, like all of
Yeah,
them would.
yes, of course, the answer is yes. It will have to. Of course, if you're dealing with property that sometimes you may make a will, and during the course of time, some of the assets mentioned in the will might be exhausted. You may have had five bank accounts at one point, three of them might be exhausted, or that sort of thing. It does not it does not affect the validity of the will. The will would only probate will only deal with what is actually there at the point of death. Now, if you name children as beneficiaries and you would have made them, let's say, joint account holders with you, for instance, they would be able to control the cash through the joint account. If we did a deed of gift, that property is now theirs. But as long as there is property that was not dealt with in terms of transferring or anything like that, there's property in the estate. The fact that you name them as beneficiaries does not give them access to it. They would still have to apply for probate, whatever is in the estate of debt, apply for probate in order to access it. If it's in the bank, if it's an insurance policy, if it's title to deed, if it's the ownership of a vehicle or property, they would still need the grant of probate to have access.
Yeah, okay, good. And then someone is asking, could you leave a husband out of a will if he met you with your property first? That
Well,
you put.
let's all right. Well, I guess we could say the spouse. You can
Mm,
leave that spouse out. Yes. If you see, the thing about a will is that the will deals with the situation that exists at the point of death. All right. Now we're talking here, it sounds to me like we're dealing with matrimonial property and who is entitled to what. Well, I should probably give a simple answer. If this is your property, well then, if you don't make the will, the spouse will be entitled to share as the next of kin. If it's your property and you make a will, making a will, you can determine who gets that property. All right, I think that's about as clear, right? Right? If
yeah,
this house, let's say, is yours exclusively, you make a will. There's no the spouse cannot claim it. Of course, if it's a matrimonial home, where the parties were living, there could be an entitlement to reside in the matrimonial home. But of course, that that might not be that might not override what you would specify in the will, right? So, I mean, situations have to be, dealt with based on, you're talking about two different areas of law intersecting here, matrimonial rights as opposed to your right as owner. But I would give the simpler opinion that if it's your property, then you can deal with that on the will, however you want to deal with that.
Mm-hmm.
If you don't deal with it, the spouse will be able to claim it by virtue of being your next of kin.
All right. Deep stuff. And, so the whole intent of this evening is to bring awareness as to some of the ramifications concerning what do we leave behind and whom do we leave in distress, or just make the pathway smooth for them. And every situation is unique, and we would advise you to seek legal advice as to what might be best for you in terms of the particular varied documents. And a will is a good idea. And to have one, even you don't need to be unwell, you don't need to have a headache for decades. You can just put it there in case of an emergency. And as you rightly mentioned, the Scobie, even having you may be mentally ill, and that might take you into death. So you may not have that opportunity towards the end to really put things in place. So or you talked about folks getting strokes and being debilitated and not having that awareness. So let's not wait until the end to get this in place. You may not have that opportunity to do so, and family members can end up paying a lot, and time wise as well as financially. And prenuptial agreements. Okay, at some point we need to move on. And so, Elder Scobie, can you share with us how can we reach you for those who may want to apply for your services? And I'll put that in the chat.
What I'm seeing, I don't know if I think I saw one question that there was one
Now like
question
about
about,
four. I think you spoke to this one about the living trust already. You did
yeah.
mention that. Okay, if a
Someone was
spouse.
asking about, I think the first question, in terms of wills, you said it could be done informally in the presence of two witnesses. I'm thinking that that is very tricky, as
Okay.
it could leave place for foul play. There are other measures to safeguard this process.
Anyone.
When it comes to foul play, where wills are concerned, I've always heard it said that most of the wills that are admitted to probate are forgery. Now, I don't know. I don't know that at all. The point about it is that the process is a simple one, and there's always room for abuse, but the law requires basically that you must have two persons present. That is the threshold. Two persons present at the same time must witness the signature. And apart from that, I think it is up to each individual, each person to put in place reasonable safeguards to ensure that your wishes are carried out. But you cannot guarantee that people wouldn't do crazy things. This is the
Mm-hmm.
broken world we are in. So we've just got to do our best.
Okay, prenuptial agreements, does that override a will? I mean, a will is your last will and testament.
But in Trinidad and Tobago, prenuptial agreements are not generally honored.
Mm.
They are not generally honored. So that of course, there is a doctrine that if you made a will before marriage, it is cancelled by your marriage. Right? If you made a will before marriage, then you should be sure to make another one after you're married. Of
Okay.
course, if it is done in contemplation of marriage, there could be a little difference here. But these are things that, of course, you need to get specific advice on. But prenuptial agreements, as far as I'm aware, they are not upheld in Trinidad and Tobago.
Okay. And a deed of gift, just to confirm, does that need to be probated to get a grant of probate? Deed of
No,
gift.
no, no. A deed of gift is one way to avoid having to apply for probate or letters of administration.
Okay. Very good. All right. Thank you so much. And I just want to, having a deed of gift and passing that on, even to an institution, a church, that can be an option as well, because situations of people, they may give to their family, but they may also want to give into the service of the Lord. So, and they may probably do it as a deed of gift. But I just want to share another statement here, based on councils on stewardship, and many are not exercised upon the subject of making their will. We don't really think about it seriously, given that we may be in good health, but this precaution should be taken by our brethren. They should know their financial standing and should not allow their business to become entangled, and they should arrange their property in such a manner as they may leave it at any time. And so I'm just sharing this to show that we do have guidance as to what, encouraging us to really consider these subject matters that we've spoken about here today. Wills should be made in a manner to stand the test of law. All right, so don't write one and then put it under the bushel and think, it's gonna get through if it doesn't meet the parameters of the will. And that was shared with us, meaning that it must be witnessed by two persons being present, and and having that residuary clause to capture all things. And after they're drawn, they may remain for years and do no harm. And if donations continue to be made from time to time as the cause has need, death will not become that will not come any day sooner. So it's not a thing that you're making a will that you're calling death upon you. No. But it's just having a safe way to dispose of your property when the time comes. So you are God's agents, and you're required by Him to hold His property and His claims. And so we are stewards of what God has blessed us with. And therefore, taking that responsibility to distribute it as to how we desire, but also in line with what the Lord would have us to do. There's counsel also for if your family, they're wealthy, they have already, it is not obligatory that we have to leave all for them or the majority for them. You could share it otherwise as God would put within your heart. So how to make your property secure? Would you make your property secure? Place it in the hand that bears the nail print of the crucifixion. Retain it in your possession, and it would be nailed to your eternal loss. Give it to God and put that, and from that moment, it bears His inspiration. It is sealed with His immutability. So there are some people who would give those gifts, donations, even while they are alive, to further the course of the work of God. And God is pleased with that. And so let's seek to do that so no one else could come, or even the court of law can come in and distribute the monies in a different way that would meet it. And here is a website that I came across, willplan.org. And there's some more content there that you could go up and read about. All in all, estate planning isn't about how wealthy you are or how old you are. It's about being a good, faithful steward with what God has blessed you with, what He's given you to manage while you're here. And even if you have relatively modest estate, you want to arrange for it to be handled carefully with your own intentions and conviction of mind. So I think that's pretty deep counsel that we can look into. Okay, thank you, Dale Scobie. You've put your contact there for phone numbers as well as email. And you can reach Dale Scobie. It's a good keepsake. Take those numbers down and keep it safe so that you can reach it. I'll just repeat it for those who will listen later. It's in Trinidad, so area code 1868 627-1560. I repeat, phone number 1-868-627-1560 or 1-868 681-88, and that's 77. Okay, 681-8877. And the email is Scobie, SCOBIE LAW, scobielaw at gmail.com. So, and I put it in the description of the recording of this video as well. So thank you everyone for your attendance, for your participation. We really do appreciate your presence here with us week after week, and we do look forward to meeting with you next week. Let's close with a word of prayer. Heavenly Father, we want to give you thanks for what you have shared with us today. We thank you so much for Elder Scobie's presence with us and for the knowledge that you have blessed him with to be able to share this in such a simple manner for our understanding. We do appreciate all that he has shared and put forward. Be with us all now as we separate, and even as we daily seek to keep ourselves in good health as you will bless us. And let us also contemplate and not be kept off guard, but put our house in order as you have counseled us to do. This is our prayer in Jesus' name. Amen.